Workers have resisted the autocratic dictates of the boss or the aristocracy throughout recorded history. But it was the Industrial Revolution in the late 18th and early 19th centuries that produced the first early forms of trade unions in Great Britain. Workers arriving in Canada from Britain and other parts of Europe not only brought their skills and labor, but also the knowledge that working conditions could be changed through collective action. They understood that by acting together, workers could counter the power wielded by employers. Child labor, the 72-hour work week, and low pay were the labor standards of the day. Canada's first unions were formed by workers who possessed a craft, such as in the printing industry. Printers in central Canada started the Société Typographique in 1827, which still exists today as part of CEP Local 591G, based in southern Ontario. Unions were not legal in Canada prior to 1872, and there was no such thing as labor laws. Those forming a union could be charged with criminal conspiracy, and many union leaders were actually jailed for leading strikes. But the gains made by workers in Britain and the U.S. were already spreading. Parliament passed the Trade Union Act of 1872, which provided immunity from prosecution for an act of combining to improve working conditions. It was no longer against the law to organize or to go on strike. The Trade Union Act and subsequent legislation paralleled laws that had already been enacted in Britain and the United States. Much of our modern legislation continues to reflect labor laws that were enacted in the U.S. during and following World War II. In 1944, Parliament proclaimed Privy Council Order 1003, giving workers the right to choose a union and imposing a system of collective bargaining. Borrowing heavily from American legislation, strikes during the term of a contract became illegal. Grievance procedures were now mandatory to give employers and unions a means of curbing unfair labor practices during the term of a collective agreement. Despite the similarities, our labor laws differ from Britain and the U.S. in some significant ways. In those other countries, labor legislation is national in scope, while most labor relations in Canada is governed by the provinces. The exception to that are industries that are considered to be in the national interest or are interprovincial in nature, such as banks, telecommunications, broadcasting, and transportation. These industries fall under the jurisdiction of the Canada Labour Code.
Local 450 is on strike. Please respect our picket lines. Do not cross our picket lines. Our picket lines are illegal.
Another unique Canadian feature is the delay of work stoppage. Under Canadian law, unions and employers must meet certain requirements, such as mediation, before a strike or lockout takes place. Other procedures include advance strike notice and conducting a strike vote, which in some jurisdictions is overseen by the government. A further made-in-Canada element of our laws is called the Rand Formula. It is named after Supreme Court Justice Ivan Rand, who issued an arbitration decision in 1945 that ended a strike at Ford Motor Company in Windsor, Ontario. Today we often refer to the formula as union security, because it requires an employer to deduct union dues from all bargaining unit workers, whether they are members of the union or not. Justice Rand based his decision on the assumption that unions are essential for all workers, and that the union must be accountable to all workers. Today, most collective agreements contain provisions similar to the Rand formula. In 2007, the Supreme Court of Canada extensively reviewed the rationale for considering collective bargaining to be a human right. In a landmark ruling, the court made the following observations. The right to bargain collectively with an employer enhances the human dignity, liberty, and autonomy of workers by giving them the opportunity to influence establishment of workplace rules and thereby gain some control over a major aspect of their lives, namely their work. Article 23 of the Universal Declaration of Human Rights, adopted by the United Nations in 1948, identifies the ability to organize trade unions as a fundamental human right. Our modern-day labor relations system makes it possible for CEP and other unions to negotiate wages, benefits, and working conditions that are far better than most employers would provide to non-union workers. Without a union, each worker stands alone when facing unsafe situations or unfair treatment from the boss. Despite Canadian and international law, many employers refuse to accept these rights. Companies ranging from small businesses to Walmart continue to oppose union organizing and bargaining efforts. For CEP and all trade unions, it is a never-ending struggle.